So, meine sehr verehrten Damen und Herren, ich freue mich sehr, Sie jetzt auf die andere Seite des Atlantiks zu entführen. No worries, that were the last German words that you hear from me in the next 30 minutes. I just wanted to raise the attention. I now have the pleasure to give you an update on EU healthcare compliance. And you will see that we also have kind of case law that is similar to the Park Doctrine, but I try to make it less dramatic as you did. A brief view on the agenda. I will start by updating you on an EU level. Most of you will know that we don't have such an EU healthcare law, or we have a harmonized standard when it comes to the cooperation or interactions with healthcare professionals and healthcare organizations. So internationally active companies might face a challenging situation when you have a kind of business activity or you have the intention to do an interaction with healthcare professionals from several member states, that you face different legal requirements, different legal regimes. This is a bad message, but nevertheless, there are solutions for it, practical solutions. And I've just said that we don't have a harmonized standard. This changed recently, last year, because the MDR, now also the EU Medical Device Regulation, which we will also cover a bit later this afternoon, is now giving guidance about the product-related advertisement. So this is quite interesting, I believe. Very happy to update you there. And I said we don't have harmonized standard, so we have to do a country-by-country analysis, and I'm very happy to give you an update on the key markets where we have recently seen some new trends, some new legislation, some new case law. And this, in this case, these days, covers in particular Germany, Italy, the Netherlands, and France. So, starting with the EU healthcare compliance regime. As I just said, there is not such an EU law where you can just have to look up and then you see all the legal requirements that you need to know for any kind of interaction with healthcare organizations, healthcare professionals, patient organizations, or patients. So, the bad news is, or the bad message is, you can face 27 different legal requirements in the different member states. So this is a challenging situation, and we don't face such a challenging situation in other legal regimes. So when it comes to the already mentioned EU Medical Device Regulation, which applies since May last year, we can say that when it comes to manufacturing, legally placing medical devices on the market, clinical investigations, labeling, packaging, then you have a fully harmonized standard. Only courts in the national member states can have a different interpretation of a legal requirement, but it's a regulation, so it's directly applicable. The same applies to GDPR. It's also a regulation, and Oliver will tell you a bit later about this afternoon. That was the bad or the negative message that I have to give on an EU level, but nevertheless, you have principles, major principles about this cooperation with healthcare organizations and healthcare professionals. This is a principle of transparency, separation, equivalence, and documentation. You all know this. When you engage with a healthcare professional, it's the principle of equivalence. You have to pay fair market value for the service rendered. Everything needs to be in writing. You have to obtain an employer consent if he or she is employed at a medical institution. So these are the general principles that apply EU-wide, and I believe also in the US, worldwide, I would say. So what you can do as a US company who is approaching the union market, which includes several member states, you can have a look at the METEC Europe Code of Ethical Business Practice, because this is a very, very good summary of all the legal requirements that are applying in the other member states. And what you can also have as a very good legal reference is the compliance handbook. It's a country-by-country analysis from METEC Europe, where specific or country-specific particularities exist in the respective countries. So when you want to achieve already, I would say, a reasonable level of legal certainty, if you are doing a multi-country cooperation with healthcare professionals, have a first look at the METEC Europe Code of Ethical Business Practice, and then check in the compliance handbook, which is renewed and updated every second year from METEC Europe, if there are country-specific requirements that you have to consider. So this is my advice. When you're seeing the situation, there is no harmonized standard, but use the reference, the two references, when you want to get a first impression, and when you want to get 100% legal certainty, then of course reach out to local counsel. So this is how you can deal with the non-harmonized standard. We now, I've said in theory, we have 27 different legal regimes applying to the cooperation with healthcare professionals. This does not apply anymore for product-related advertisement. Because quite surprisingly, because the EU medical device regulation is a regulatory law and normally only addresses what do I have to do to run through the conformity assessment procedure, what do I have to do if I put my technical documentation together, what do I do with my notified body in the cooperation, how do I have to manufacture, how do I have to produce and also label my medical devices. So in Article 7, you out of a sudden, we were all surprised, found rules about product-related advertisement for medical devices. And this Article 7, I copied it here and made a summary in bold letters. So what you can see in this Article 7, which applies now for 16 months, that you can see there are the general principle, of course, summarized, prohibition of misleading advertisement. This is nothing new. You all knew this. This applies worldwide. So in Article 7, subsection A and B, it's a summary of the prohibition of misleading advertisement. What is very new in Europe, and to my best knowledge in all the member states, that we are now required to also include mandatory information in product-related advertisement. So whenever you provide information that are of promotional character to patients or to healthcare professionals, you have to include or you have to inform the user or the patient of the likely risk that is associated when the medical device is used within its intended purpose. I think you're already familiar with this in the US, but this is new in Germany and all the other member states. So mandatory informations now also apply to product-related advertisement for medical devices. Still very unclear to us how this requirement will be interpreted, because what you can see, it shall be prohibited to fail to inform the user of the patient of a likely risk. So what does it mean? How should he be informed? Should the mandatory information be directly under the safety or efficacy claim, or is it sufficient that we are having a link to the company website where you can find the instructions for use? So this is all that will be clarified then later on by national courts. So this also gives you the opportunity include mandatory information, but you're still having a lot of room how to interpret this rule. There are no official guidance or case law who's narrowing this down, this legal requirement. We heard today already quite often about the prohibition of off-label advertisement. We didn't have anything like this in Europe unless last year. Of course, from a product liability standpoint, it was always recommended to never do this because you extend your liability when you do off-label advertisement as a manufacturer. But now, first since a year, we now have the legal prohibition of off-label advertisement. That was my update on an EU level. And now I'm very quickly running you through the country-by-country updates where we have seen in the recent past new trends, legislations, and guidance that I would like to inform you about. I'm informing you about a trend or something that is not happening in Germany, and I still believe it's very unusual. There is no German Sunshine Act. This is quite special because most of the member states, one after the other, now introducing Sunshine Acts. So it's required from a legal perspective, it's mandatory that any kind of transfer of value to healthcare organizations and professionals needs to be disclosed to an authority or on a public website. We don't have anything like this in Germany. despite the public opinion is really calling for it, and all the stakeholders in Germany are really willing that the legislator is implementing one. But it's still not happening. Another trend, what we have seen, a development, is about the principle of equivalence. So you know all this fair market value needs to be paid for service rendered by a healthcare professional. We had very old case law on which we could reasonably justify an hourly rate of 150 euros for a key opinion leader when providing highly qualified medical service. That might sound ridiculous from an US perspective, but that was common practice in Germany for several years. 4 or 5, 6 years ago, we have seen an increase, so it went up to 200. And what we have seen in the last months, an acceptance from medical institutions to go up to 250. And I see this acceptance from healthcare organizations that they already say for their employees you can pay them 250 euros as an indication that this will also be accepted by German courts as fair market value when you engage with a healthcare professional and he or she is providing qualified medical service. The same, we see an increase in the meal limit. So what is the price that you are allowed to pay when you invite a healthcare professional for a business lunch or dinner? It was over years, case law from 2008 was saying it is 60 euros. And now it's planned that the German MedTech Industry Association, BVMed, will issue an official, it's not a guidance, it's an official recommendation that the meal limit should now increase up to 75 euros. And Amanda is not in the room anymore, but we also have a park doctrine in Germany. But just recently, because we had case law from the higher regional court in Nuremberg from March 2022, so from this year, in which the court has said that it is one of the duties of the managing director of a GmbH to take care of the well-being of the company. And if there is a compliance infringement and there was no sophisticated quality management system, compliance management system, no code of conduct, no further guidance or monitoring for the employees, what they need to observe when they do interactions with healthcare professionals, then this managing director could be held personally liable from a civil perspective, not from a criminal perspective. Yes, please, Alain.
Does it matter if the parent organization is doing something versus the subsidiary and you have different people as the managing director of the subsidiary? Can you get around it somehow?
I mean, you have to be the managing director of the GmbH. Sorry. Alali, I'm afraid you have to repeat the question with the microphone.
You would rephrase it so much better. My question was around when you have an American parent corporation, but you have subsidiaries in Germany that may be limited to certain activities, if you can bifurcate the responsibilities to avoid this personal liability of the managing director.
I think the addressee of this law or the case law is the managing director of the GmbH. And there you would just have a look at the public register who is fulfilling this function. And when you have an infringement within the organization from one of your employees, then they would simply check was there a robust, solid, and working compliance management system? And if not, they would just go to the managing director. And you, of course, then would be held liable, so the mother company, by maybe other means, FCPA or what kind of laws you are having here in the US. Very. Okay, this is our park doctrine that we have in Germany since a few months, now for 6 months. And if you don't have any questions about the update on Germany, very happy to inform you about the fact that the sun is now also shining in Italy. I have said that Germany, as one of the last countries, is not having a Sunshine Act, but Italy has now one, and they have implemented it. Where can I see it? That was May 2022. And before that date, it was still not mandatory, so not on a legal basis. Companies were obliged to disclose the transfer of value to healthcare professional. It was still self-regulatory, so it was only recommended by industry guidelines. And now we have an Italian Sunshine Act, but we are still somehow in a grace period or transitional period, because the public or the Italian government still needs to establish this so-called Italian healthcare register, where you then can fulfill your reporting duties on. And once this has been established from a technical perspective, then you have an additional 6 months that your reporting duties then apply. So just that you keep in mind, next year you will report something. So next year, meaning Q3 or Q4 in 2023, you will need to report any transfer of value to healthcare professionals and healthcare organizations if they are above the individual and organizational benchmarks that you see here on the slide. That's my update to Italy. Now we are coming to the Netherlands. It's not really an update, but this is something that I have seen in my practice, or I came across in my practice a few months ago, and I think it was a very nice idea to somehow not circumvent the prohibition or the recommendation of not doing direct sponsoring anymore. So you all know it's common practice, or it's a recommendation already in the US since years, and also in Europe, it's via the METEC Europe Code of Ethical Business Practice, and also by the national industry guidelines. It is recommended, not prohibited, it's recommended to not do direct sponsoring anymore. So you do not sponsor the passive participation of a healthcare professional at a third-party organized educational event. So this is direct sponsoring. It's recommended to not do this anymore in Europe since 2018. Now it's done via educational grants. If you still want to educate your users or your prescribers about your technology, you can do an educational grant to the healthcare organization, which then selects the benefiting healthcare professional who is allowed to passively participate at this third-party organized event. But what I have seen in the Netherlands, or maybe one more information I would like to give to you, the market really calls for this direct sponsoring. At least our clients in Germany and in the EU, they are really saying, we have key opinion leaders, we need them at this medical congress. We need them to send, or we would like them to be at an US congress, and is there anyhow an option that we still do this direct sponsoring? And if, because our competitors is doing this, or is constantly doing this, so if we do not send them, we get a competitive disadvantage if we are not doing it. So what we are doing, we are issuing legal opinions where we're saying it's a recommendation from the industry. Maybe you're not even member of this industry association. German law is not prohibiting it. So it's not somehow not accepted, it's not industry standard anymore, but from a legal perspective, you're still allowed to do it. And having this in mind, that any industry association is saying you should not do this anymore, the market or the practice is asking for it. I found it very charming what I've seen in the Netherlands industry, or the GMH industry code of conduct. They have simply said you can still do it unless you do not reach certain limits or certain benchmarks, or you're not exceeding certain limits and benchmarks. So it says if the company is not contributing more than 500 euro to a healthcare professional for this direct sponsoring, or not more than 1,500 per year, it's still okay, it's still acceptable. And what I've also seen is quite common. It's accepted when the healthcare professional is paying 50% of the expenses on his or her own. This is quite interesting, because then they do the model, we sponsor your participation, but you give a speech at this conference, you get a fee for it, and the fee covers the 50% of the expenses. So I think it's a quite charming, not trick, or I would say, a quite good approach to circumvent this recommendation to not do direct sponsoring anymore. So the last country update is France. We have a new law in France, or a new Charta, which is called the French Charta for the Presentation of Educational Information and Promotion of Medical Devices for Individual Use. It has been implemented in March 2022. The aim of this Charta is to have a better quality of the promotional and information that are given from a manufacturer to a healthcare professional. And there are two things that I want to draw your attention to. First is, companies must implement a quality management system for their presentational, informational and promotional activity from March 2023 on. This is quite interesting because it's not only that you have to have a quality management system from a regulatory perspective that is checked and inspected by a notified body. No, you also need to have this now when you issue just information, not even of promotional character, when you issue information or promotional brochures to healthcare professionals. This is something I would like to draw your attention to. And then I found it very strict. It's also limited how much company-initiated visits a healthcare professional may have from your sales rep. So it's not allowed to have more than 4 per calendar year. And this is very French specific. I've never seen something else like this in other member states. But I'm not surprised because with the French Sunshine Act, the law Bertrand, they already have made very strict requirements for the reporting of transfer and value. And this just fits in the picture when it comes to healthcare compliance regime in France. So this was my last update, my last country-specific update, and I'm very happy to now hear your questions if you might have any. Please, over there. Wait for the microphone, please. Paul, thank you.
For France, can you give an example what you mean by QMS, implementation of presentational information?
Sorry, say it again. If I have an example of providing information.
No, what does it mean to implement QMS for presentational information? You mean to have an SOP, or what specifically that activity?
For instance, but I would very much expect that it's an SOP. You must have a responsible person like Qualitätsbeauftragter a quality responsible person for also that checks the informations and the promotion that are issued to healthcare professionals. Maybe an SOP requires a check from the legal department, from the regulatory department. I would expect something like that. But the criteria are not yet set. That's why we are still in the transitional period. So you can obtain this certificate only from March 2023 on. You're welcome. Any other questions from the room or from the audience remotely?
Nothing remotely.
Okay, thank you. Then I'm very happy to hand over. Mark, is it you taking over then? Please, the stage is yours.